Well, hello everyone. Thank you for joining my colleague Anke Saßmannshausen and myself for today's ESG session. Policies and laws governing supply chains are increasing and are changing around the globe. And today's subject is the German Supply Chain Act, officially called the Act on Corporate Due Diligence Obligations for the Prevention of Human Rights Violations in Supply Chains. This is why I will just briefly refer to it as the Act or Supply Chain Act in the following webinar. The Act has just entered into force 2.5 months ago after a long legislative procedure and discussions, and it is considered an important milestone, continuing the trend of increasing ESG regulation of businesses worldwide. It will have an impact on markets far beyond Germany. The aim of this Act is to make globalized supply chains socially and environmentally sustainable and anchor human rights and certain environmental considerations in companies' operations and the governance. The starting point were the UN guiding principles on business and human rights and the German government's national action plan based on these principles, which relied on a voluntary self-commitment. However, the hope for effects failed to materialize, which is why we ended up with the Supply Chain Act. In February last year, the EU Commission adopted a proposal for a European directive also on corporate sustainability due diligence obligations. And so a EU-wide regulation is on its way. And this means that the current German Act is only a transitional phase and it will further undergo a couple of changes in the near future. But now let's take a look at today's agenda first. One second. Yeah. Today, I will just give you a high-level overview of the contents and structure of the German Supply Chain Act and will explain which companies fall directly within the scope of the Act. I will also take a quick glance on the EU proposal for Supply Chain Directive, and I will then hand over to my colleague Anke, who will take a closer look at the legal texts and drafting of contracts, liability issues, and sanctions. The second part of this webinar is moderated by Alex Bandza and of the US law firm Barnes and Thornburg, who will then talk about topical ESG developments in the US. But let's start with basics regarding the German Supply Chain Act. The Act entered into force in the beginning of January, and it obliges entities falling within its scope to adequately and comply with human rights and environmental due diligence obligations in their supply chains. Which entities fall directly under the scope of application? Initially, this has been from January this year. These are companies regardless of their legal form. So this also applies to public law institutions with at least 3,000 employees in Germany. And as of next year, 2024, this threshold will drop to 1,000 employees. The company must be headquartered or have its administrative or corporate seat or just a branch office in Germany. So you may now think that the impact on my company, if it is located in the US or elsewhere outside Germany, or has fewer employees, what's the impact of this act? It would still be very likely that the Supply Chain Act will have an impact on the business of your company in case your company is a contractual partner or direct supplier of an in-scope company. Or in other words, if your company has large German enterprises as customers. This is why it is important to get familiar with the Act, this new legislation, and also anticipate that German in-scope customers will require ESG-related information and impose related safeguards as a condition to do business with them. Now let's take a closer look at the term supply chain. I will read this important definition to you. One second. This is defined in the Act itself. The supply chain within the meaning of the Act refers to all products and services of an enterprise and includes all steps in Germany and abroad that are necessary to produce the products and provide the services, starting from the extraction of raw materials up to the delivery to end customers. And it includes actions of an enterprise in its own business area, the actions of direct suppliers, and the actions of indirect suppliers. I will get back to these three tiers in a moment when talking about the due diligence obligations a company has to fulfill with regard to its supply chain, but I will first now touch on the protected legal positions within the supply chain, which are formulated as prohibitions in Section 2 of the Act. Yeah, well, you have an overview on the slide, and the Act refers to various international conventions enshrining human rights. The protection of human rights in the Supply Chain Act is certainly the main focus of the Act, and there are also 3 areas in this respect. The protection of employees, covering the prohibition of forced labor, modern slavery, child labor, unequal treatment of employees, and freedom of association, to name a few of them. Another area is the protection of natural resources, and there's also a category regarding protection of from security forces, which is about the prevention of violence. Environmental concerns are protected only to a limited extent. And this is particularly where environment-related risks lead to human rights violations, and where certain chemicals and substances become hazardous to people and the environment. These environment-related obligations stem from 3 international conventions: the Minamata Convention, dealing with the prohibition of mercury-added products and use of mercury; the Stockholm or POPs Convention, dealing with the production and use of persistent organic pollutants; as well as the Basel Convention regarding bans on the export and import of hazardous waste. Climate protection is so far not covered by the Act, but this will change in the near future because the EU Directive, which is proposed, will touch on this subject. The human rights and environmental risks shown in this overview must be prevented and minimized through compliance with the due diligence obligations. And let's therefore dive into the core piece of the Supply Chain Act, which are the due diligence obligations. I will try to make it not too long, but these are all the due diligence obligations, which are all covered by the various sections of the Act. And Anke will talk in a bit about the indirect effects also on out-of-scope companies of these obligations. The first obligations are the requirements to set up a risk management system and carry out a risk analysis. The establishment of adequate and effective risk management requires, among other things, of course, that the designation of a person who's responsible for monitoring the risks, and to report this to the management. The Act suggests, for example, to appoint a human rights officer, and the management must at least once a year inform itself about the work of this designated person. As part of the risk analysis, enterprises have to identify, weigh, and prioritize the risks in their supply chains. The risk analysis must also be reviewed on an annual basis and on ad hoc basis if there are any incidents or changes. For example, different sourcing origins and changed products. These would be triggering a new risk analysis in some instances. At this point, I would also like to mention the BAFA. This is the Federal Office of Economics and Export Control. This is the competent German supervising authority. And this authority has also published on its website a couple of very helpful handouts and guidances on how to conduct the risk analysis and do the reporting. And some of this is also available in the English language. Next, there's also a policy statement on the human rights strategy, in which the procedures for complying with human rights and environmental due diligence obligations are described, and which specifies particular risks identified as a result of the analysis. The statement shall also define the company's expectations towards its own employees and its suppliers. Wherever a risk is identified, companies must anchor risk-based preventive measures, and they depend on the type and level of risk. In their own supply and their own business area, this should in particular include the development of suitable procurement strategies and purchasing practices. This also includes contractual assurances, but this is what my colleague will talk about in a moment. The implementation of training and risk-based control measures are also part of this. And with regard to direct suppliers, human rights and environmental expectations should also be taken into account in the selection process. which is why you may come across self-assessment questionnaires and similar ways to deal with this. Remedial action must be taken in event of violations. If company determines that there is a violation of a protected legal position, or this is imminent in its own business area or with a direct supplier, or if it has substantiated knowledge in this respect with regard to an indirect supplier, then appropriate remedial action must be taken immediately. And it is important to note that in its own business area, a company must eliminate the violation. The termination of a business relationship with a direct supplier who violates the human rights or environmental related positions is only required in very exceptional cases where we have severe violations or other measures haven't worked out. So there's also a requirement to set up a complaints procedure. This is a whistleblowing system which must be implemented, which enables internal and external stakeholders to notify violations that have arisen as a result of the company's business activities. And the rules of procedure must also be made publicly available. The due diligence obligations described are also flanked by reporting and documentation obligations, and entities falling within the scope must also annually submit a report electronically to the supervisory authority, to the BAFA. It is very important to note that all these obligations, that there's no obligation to succeed, but only an obligation to make an effort and comply with the duties in an appropriate manner, meaning that in-scope companies are not obliged to prevent all human rights and environmental violations outside their own business area, but that it's rather determined on a case-by-case basis which measures are appropriate and reasonable for the respective company. And this also takes into account the ability to influence the situation, the expected severity of a violation, and the reversibility of a violation, nature of contribution, and so on. Well, this is in a nutshell about the due diligence obligations. And on the next slide, I was going to explain the calculation of the thresholds to determine whether a company is in scope of the Act. But I think this will, due to the time constraints, I will skip this part, and it will get too long to get into these details. I already explained very briefly the principles that directly a company only falls within the scope of the Act if it is headquartered in Germany, or if it has its administrative seat or branch office in Germany. And not only full-time employees are counted towards the thresholds, but also other types of employment, which are shown in the slide. And just one thing I would like to mention is that in case of affiliated companies, there are certain attribution mechanisms that apply and which are shown on the next slide. And pursuant to the Act, all employees of affiliated enterprises employed in Germany are taken into account when calculating the number of employees of a parent company. This means that, for example, if a parent company must consider the headcount of its subsidiaries and second-tier subsidiaries, and it is also important to note that employees are always counted from bottom to top and not considered at each individual level, but only at the top group parent company. And also, please bear in mind that the scope of consolidation only includes domestic German parts of the group of consolidated companies. But now let's get to the legal situation in Europe. What is to come here? There's a draft of a Corporate Sustainability Due Diligence Directive. This has been published and was presented last year in February and by the European Commission, and it is still going through the legislative process. This also aims at setting a framework for better human rights and environmental protection, and the European approach is, of course, chosen to avoid further fragmentation resulting from member states' own national approaches, as we have it right now in Germany. And well, what can be said about this directive is that it will lead to an expansion of the due diligence obligations and the scope of application as compared to the German Act. As you can see here on the slide, the headcount thresholds are lower, but they are combined with certain minimum revenue requirements, and which are even lower in case of high impact sectors, which are, for example, textiles industry, agriculture. And in any case, more companies will therefore fall directly in the scope of application, and it will also cover, the directive will also cover non-EU based companies which have substantial business within the EU. So different from the German Supply Chain Act, the proposed directive sets out certain obligations that also support the achievement of the EU's climate targets, and therefore this also aims at combating the climate change, which is not yet covered by the German Act. Liability and sanctions will also be further reaching as compared to the German current Act, and this will widen the civil law liability. And the proposed directive explicitly provides for civil law liability for due diligence violation. And the liability is not just limited to a company's own violations, but may also even extend to violations by subsidiaries or suppliers. So let's take a look at the further legislative process. Now, following the EU Commission's draft on the directive in February last year, the European Parliament published a draft report last November, and on 1st of December, the European Council formally adopted its negotiating position. That's called Council's General Approach. And the EU Council's approach narrows the scope of the European directive. Just to give two examples, the Commission proposed, for example, that the directive does not apply to the entire value chain, but member states have opted to introduce the concept of chain of activities, which is more or less the same as supply chain. And this covers mainly a company's upstream business partners, and not, or only to a limited extent, the downstream business partners. And regarding the thresholds related to company employees and turnover, the Council has largely maintained the Commission's proposal. But the Council's approach is that it has introduced a gradual phase-in period based on the size of a company. So similar as we have it in Germany now, that the threshold dropped after the first year or second year. And so this is how it is planned for the EU too. So what is next? The EU Parliament will still have a few months to adopt its official position, which will then allow the trilogue negotiation process between the three institutions within the EU. And the final text of the directive can therefore not be expected before the end of this year, or rather, we think early 2024 will be more realistic. And the next slide shows the time frame again, the timeline. Well, and considering that there are very different positions within the three EU institutions that have already shown and become apparent, it is difficult to really predict the exact time frame. But one thing is obvious, that the longer this takes, the more time there is to get familiar and to already adapt to these new requirements. Before I pass on to my colleague Anke, I would also like to mention another piece of ESG regulation, which we don't really go into the details, but which also stands next to the Corporate Sustainability Due Diligence Directive. This is the Corporate Sustainability Reporting Directive. This reporting directive has been already adopted in the end of last year, but the transition period for the member states runs until next year, July. And this reporting directive enlarges the number of European entities and groups which need to do reporting on environmental and social impact activities in their annual management report and in the consolidated management report. And it defines the required sustainability content in more detail. But now, Anke, I hope this wasn't too long, but you can now explain a bit more in detail the contractual situation between suppliers and customers in the light of the new German Act.
Yes, thank you very much, Sara. Now that we have had an overview of the scope of the Act, the individual due diligence obligations, and in particular the addressees, I would like to take a view at how the addressees of the Act must reflect their due diligence obligations when structuring their contracts within the supply chain. And what is the more likely scenario if you are, let's say, a US company with customers in Germany? That is, if your company is not itself an adversary of the Act, you may have already been confronted with such requests if you are in business with major German customers who fall within the scope of the Act. As a first step, we see that companies are increasing their efforts to perform due diligence on their suppliers before starting new business relationships, and also to extend their ongoing due diligence procedures with existing suppliers. There is a variety of tools and services available to help in this process, such as online questionnaires for the identification and evaluation of risks in the supply chain. Also, many companies require their suppliers to provide self-assessment questionnaires, which touch on the requirements of the Act, as well as more general aspects of ESG compliance. We therefore expect that such assessment will be standard for future business with German customers, and that even companies not directly affected by the Act will use such tools or self-assessments to enhance their ESG footprint. For the actual contractual relationships, it is required that adversees of the Act must obtain so-called contractual assurances from their direct suppliers that they will comply with their expectations regarding the protection of human rights and the environment, and that they will address them appropriately along the supply chain. As a result, direct suppliers will be required to pass on certain obligations to their own suppliers. As Sara has already pointed out, the due diligence obligations from the Act are therefore not only relevant for companies directly affected by the Act, but also filter through the different levels of supply chain by way of contractual agreements. Even if your company is not itself a norm adversee, you should therefore familiarize yourself with the obligations arising from the Act. We can just go to the next slide, where we can take a closer look at the documents the adversees of the Act should have in place exactly to ensure compliance with due diligence obligations along the supply chain. And if you're a supplier, what to expect when it comes to such obligations. First of all, as Sara has already mentioned, there is an obligation for the adversees of the Act to draw up a policy statement that sets out the company's human rights strategy and its expectations towards the supply chain. This includes, for example, setting out a strategy for the selection and ongoing management of suppliers. The policy statement must also be communicated to direct suppliers. While the policy statement sets out the basic pillars for the human rights strategy, companies will specify their expectations for their suppliers in a supplier code of conduct. By this means, their expectations towards the supplier can be specifically identified and included in the contracts with the supplier. This can be done, for example, by means of an annex to the supply contract, or by way of a reference in general terms and conditions. In individual cases, it may also be necessary to agree on special terms with individual suppliers. For example, if there is an increased risk in relation to such supplier. In this case, companies may consider to define their suppliers' obligations and possible remedial actions in more detail in framework supply agreements, for example. In the course of contract negotiations along the supply chain, it should also be taken into account that certain commercial parameters may conflict with the prevention of human rights violations. For example, very short delivery times, low purchase prices, or long payment terms can intensify problematic conditions with regard to the human rights situation at the level of the supplier or sub-supplier. So what exactly will the adversees of the Act include in their contracts with direct suppliers? Let's take a look at the next slide. First and foremost, contracts will aim at preventing violations of human rights or environmental-related rights. To this end, suppliers will be required to comply with the requirements of the Supplier Code of Conduct. The adversees of the Act will likely ask for certain flexibility by establishing a right to amend the Supplier Code of Conduct as need be. This may become relevant, for example, if the supplier code of conduct needs to be adapted due to a changed risk analysis. Furthermore, changes in statutory law, in particular the implementation of the EU legislation, may require such changes, which may already be anticipated by making the code of conduct and other contractual provisions subject to alterations. As a preventive measure, it is also possible to request suppliers to purchase certain products only from selected and previously audited sub-suppliers, or to ask for certain product certifications. In addition, obligations to conduct training or further education with regard to human rights due diligence can be stipulated in the contract. The next pillar are control mechanisms for the enforcement of the human rights related obligations. This can be done via on-site inspections or audits carried out by third parties. Finally, it's important for the addressees of the Act that the contract provides for appropriate remedial measures that take effect when a direct supplier violates its due diligence obligation or a violation is imminent. A plan to end or minimize the breach must then be established. That is, the supplier must cooperate in developing a joint remediation plan. If necessary, the customers may join forces with other companies within the scope of industry initiatives and industry standards in order to increase the possibilities of exerting influence on the supplier. It may even be appropriate to temporarily suspend the business relationship with the supplier. However, termination is only necessary as a last resort if the violation is very serious. In order to comply with the obligations of the Act, it is also important to have a so-called pass-on clause. This is a clause which ensures that the supplier must pass on its human rights due diligence obligations within the supply chain, in order to enable measures to be taken against indirect suppliers. This being said, if you are a direct supplier to a customer subject to the Act, you may be required to adjust your contracts with your own suppliers in order to be compliant with your obligations towards your customers. And as previously mentioned, it makes total sense to run a sanity check of the obligations your customers want to impose on you. If such obligations go beyond the scope of what is actually legally required, then you may have a better negotiation position. So now, before we pass on to Alex, I will just very briefly show the slides on the liability and sanctions. So first and foremost, there are public law sanctions which may be imposed on the addressees of the Act. The exclusion from the award of public contracts for up to 3 years, a penalty of up to 50,000 euros in case of violations of administrative orders, and also fines of up to 800,000 euros or 2% of the annual turnover. There may also be civil liability, but this is nothing which is particularly set out by the Act, but general provisions will apply in this respect. Maybe we can just show the last slide, but I will not go into any further detail to give floor to Alex, who will now provide valuable insight on the current stage of the ESG regulation in the US. Thank you so much.
Thank you, Sara and Anke, and I'm back from my cave to finish off the thought from before. One of the things that we really relished in planning this is the ability from different jurisdictions to learn from each other. And by way of overview, again, Alex Bandza, partner in the environmental group at Barnes and Thornburg in Chicago. And so a lot of what we just saw on the EU and in particular German side is law now, or forthcoming law, whereas a lot of what I'll talk about here, if we could go to the next slide, will be many different proposals and many things that in typical American fashion will likely be subject to litigation. And so in brief, we have, in terms of the regulatory portion of this presentation on the US, the regulations stemming from the Biden administration's executive action specific to climate-related risk. We'll take a look briefly at the Federal Trade Commission's green guides, some sector-specific bank and insurance and financial industry regulations, and then wanted to highlight in particular some very aggressive actions coming out of California. So to start at the beginning, which isn't that long ago, in May of 2021, the Biden administration issued an executive order related to climate-related financial risk, which articulated, as you see here, a three-part policy, which was to advance disclosure of climate-related financial risk. It was to mitigate that risk and its drivers, and additionally addressing disparate impacts on disadvantaged communities and communities of color. And also the third, to achieve a target of a net zero emissions economy by 2050. So certainly audacious, but overall, it's directed at federal agencies that administer federal programs, which we'll see in just a moment. So the big one, the Mac Daddy, I guess, is the Securities and Exchange Commission's climate-related disclosure rule that came out. So just to level set here, the target here is for public companies or for reporting companies under the SEC. So these are companies that subject to reporting requirements and must file certain reports. Typically, this is done in connection with if they issue securities or by registering securities with the SEC. Now, arguably, some of what is currently existing by way of regulation at the SEC, so this is in particular SK, has some notions that get to ESG related factors. So under the first item identified here, the purpose of reporting compliance is to look at material, what could have a material effect on compliance under state, local, and federal law upon the registrant. The next on human capital, which is to look at material impacts related to human capital resources. Legal proceedings specifically encompasses environmental proceedings, as you see under item 103. And then sort of a catch-all, item 105, looking at risk factors that make or could make a offering speculative or risky. So in 2022, we have the proposal, which is the enhancement and standardization of climate-related disclosures for investors. And so the proposed rule would require that domestic and foreign issuers provide in their registration statements and periodic reports information on climate-related financial risks. And so some of the top line risks or issues are identified here. There's climate-related risks that may impact the business strategy and outlook. There's governance-related risks that stem from climate-related risks, as noted in bold and red here. An assessment of greenhouse gas emissions, including possible third-party attestations. And the final two, metrics and disclosing metrics, if those are part of a business, including planning targets, goals, and transition plans. And so to note, by way of the many standards that are discussed in the space, this is based in part on the Task Force on Climate-Related Disclosures. And so this is, you can consider it 4 pillars. There's governance, there's strategy, there's risk management, and there's metrics and targets. However, these are distinguished in a couple respects. And so, as noted above, and you see here a brief detour into the controversial or at least very interesting portion of the SEC climate rule is what's called Scope 3 emissions. So you have an overview here, but just by way of overview, emission scopes are categories of sources of greenhouse gases that are generated by companies, and they're typically divided into scopes 1, 2, and 3. So these provide measurement criteria that can be used to calculate GHG emissions and serve as a basis for reduction goals. Scopes 1 and 2 are emissions that are directly attributable to a company's operations and can be measured usually a little more easily with respect to energy consumption or other publicly available data. Scope 3 emissions, on the other hand, are a result of activities from assets and operations not owned or controlled by the reporting organization, but that indirectly affects its value chain. And so these are sometimes referred to as value chain emissions, and for some companies in particular, say, oil or energy companies, they can present the majority of an organization's total greenhouse gas related emissions. This is one of the more controversial portions, as mentioned, of the SEC's rule. It's generated thousands of comments. Many have complained about the undue burden, and it's anticipated that this will be a focal point of any litigation that comes out, whether statutory or constitutional, challenging whether this rule is even permissible or the extent of the rule is permissible under the SEC's enabling acts. Next slide. So to close out our very quick tour of the SEC, two other rules to be aware of. First, the names rule, and second, the ESG disclosure requirements. So both came out in May of 2022. With respect to the first, the SEC views the name of a fund as a means of communicating information about the fund to investors. That's an important marketing tool. And because of the concern about perhaps the undue reliance on a fund's name to determine a client or individual's investments and potential risks, the SEC in 2001 adopted what's called the names rule to ensure that a fund's name does not misrepresent the fund's investments and risks. And so the current names rule requires that if a fund's name suggests a focus in a particular type of investment or a particular industry or geographic region, the fund must adopt a policy to invest at least 80% of its funds or value of the assets in that type of descriptor, so investment, industry, country, or geographic region. The expanded scope of the fund names rule in the proposed amendments here would include, for example, terms like growth or value, but also to bring this in line with ESG or ESG factors, including sustainable or green or ethical. The second rule, oh, sorry, if we could go back 1 second. Thank you. The second rule, the ESG disclosure requirements at a high level. There's 3 tiers which are identified here of increased disclosure requirements specific to overall incorporating ESG factors into investment decisions. So there's the first is a fund or advisor considering ESG as integrated into investment strategy. There is the second tier focused more specifically on an ESG investment strategy. And the third is seeking to achieve an ESG objective through the investments made. And so based upon the spectrum, there's different reporting obligations, there's different information that's required, and furthermore, at least in an FAQ to this, there's also DEI factors that are rolled in through again, an SEC FAQ that's posted on their website. So turning now to the Department of Labor, as indicating, and just to get to a moment, development as of yesterday, but in November of 2022, there was a final update to ERISA, so retirement plans, and what investments are permissible. The rule here was to clarify the application of ERISA's planned fiduciary duties of prudence and loyalty to selecting investments and investment courses of action, including qualified default investment alternatives, and as well as shareholder rights and proxy voting assessments. And so this was a rollback of a Trump-era rule, which limited consideration solely to pecuniary or financial factors. So what's done here is to clarify the permissibility of considering climate change and other ESG factors, including governance and workforce, on particular investments or investment courses of action. There's been lawsuits filed by Republican attorneys general challenging the scope of this rule. There was a bill that passed the Senate that would have limited the import of this rule, and just yesterday, President Biden exercised his first veto to veto that bill that would have blunted the impact of this rule. So certainly more to come on this front, but developments as of yesterday. The third action stemming from the Biden administration's proposal back in 2021 is, again, in November of 2022, a proposal to amend the federal acquisition regulations. So this applies to federal contractors. Many significant contractors are also SEC registrants. The rule here, although, goes a little bit further than the SEC rule as identified below. So the two primary ones are that the rule may require a contractor to disclose Scope 3 emissions that are not otherwise required to be disclosed under the SEC rule. And the SEC rule would not require a registrant to set emissions-related targets, science or otherwise, although if set, disclosure would be required. Here, there is a requirement to set emissions-based reduction goals on federal contractors. So switching over to, again, all these are done in around the same time, but not necessarily stemming from the Biden administration's executive orders. So the Federal Trade Commission has something called Guides for the Use of Environmental Marketing Claims, which are typically shortened to just green guides. And so this is quite broad. So this relates to any entities that market the environmental or green attributes or benefits of their products, services, or operations, not necessarily limited to public companies, but given the interest in the marketplace on sustainable or other attributes about products, this is broadly applicable. So what this is a guidance to marketers to help them make proper claims about environmental attributes. The concept or goal is to make green advertising fair, truthful, and not deceptive. There's been a bit of time, you might say a lifetime, since in the development of this area, these have been updated. So in 2012, the last version was published. As of last year and this year, there's an update proposed, and the comment period is still open. It was extended in case anybody's still interested in commenting. But some of the things that are included in this latest proposal include certificates and seals of approval, claims related to carbon offsets, quote unquote free of claims, non-toxic claims, claims about renewable energy and renewable materials used in products. A few more sector-specific items to touch upon. So 3 entities, different regulatory entities, have proposed principles for climate-related financial risk management coming in, as you can see, quick succession in 2021 and 2022. The target here is large financial institutions. And what these are a framework for climate-related financial risk exposure assessment, which touch on these 6 aspects identified here. So governance, policies, procedures, and limits, strategic planning, risk management, data management, and scenario analysis. So what we have seen is regulators signaling both they are welcoming public comment in this, but also their indication that they will work together to promote consistency through final interagency guidance. Another sector-specific development to be aware of. So the National Association of Insurance Commissioners, as well as the Federal Insurance Office, have issued standards for reporting climate-related risks. Again, these plug into the task force standard. So interestingly, the NAIC's survey has asked companies to identify and assess climate-related risks on insurance and reinsurance by geography, business division, and product segment. And more than 15 US jurisdictions have committed to requiring the NAIC survey in 2022 for insurance companies that are licensed in their jurisdiction. So this covers approximately 80% of the US insurance market. The proposal here is to collect zip code level data from insurers to assess climate-related exposures, and also to begin to assess the affordability and availability of insurance, including disruptions in the private insurance market stemming from climate-related disasters. One other to be aware of, under FINRA. FINRA is a government-authorized not-for-profit organization that oversees US broker-dealers. While FINRA has referenced ESG previously, the 2023 report is the first time FINRA has cautioned its members on communications relating to ESG. So in its communications with the public guidance, FINRA focuses on firms offering products that promote ESG factors and provides a list of questions regarding communications. So the concept here is that firms should have procedures designed to review communications to ensure that ESG related claims are consistent with and supported by applicable offering documents. Next slide, please. So to be aware of two things in California that are related and may sort of backfill against any limits or withdrawals on the scope of the SEC rule, but we see in January of this year, two bills, a Climate Corporate Data Accountability Act and Climate Related Financial Risk Act. So these acts would require that the California State Air Resources Board, before or up until January 1st, 2025, develop and adopt regulations concerning public disclosure of Scope 1, Scope 2, and importantly, Scope 3 emissions to an emissions registry. These disclosures would be required to be independently verified by an emissions registry or an auditor that's approved by the State Air Resources Board. And the Financial Risk Act, there's the requirement to prepare a climate-related financial risk report. And so as you see here, this is more expansive. It's both public and private companies. It's Scope 3 emissions, and it has third-party assurance requirements. And so this is, to the extent the SEC backtracks or portions of the rule are withdrawn or by litigation eliminated, someone as big as California in terms of GDP may actually impose comparable requirements. So this could be its own presentation, so I'll have to be brief here, mindful of time, but in the classic American tradition, there is no shortage of litigation that is coming out of all of these efforts or companies' voluntary efforts to begin to work towards these sustainability initiatives. And so in terms of targets of litigation and examples of litigation, which we'll get into in a moment, it's very broad in both respects. In terms of examples, there's many different flavors of ESG litigation that we're seeing. So class actions, toxic tort, shareholder and governance related actions. There's both individuals suing governments and there's governments as well. The last one, climate actions, suing private entities for damage to infrastructure and other effects or costs that they're incurring. So as listed, you have here basically anyone is being sued up and down the supply chain or including government actors. So you have companies that are the targets, you have boards of companies, governments when they affect private interests. So if you think of something like a permit or an other right, a different type of right that's granted, like a mining or timber or water allocation right, where you expect company intervention to defend their interests, and then as well, those in the financial ecosystem, including banks, institutional investors, brokers, fund and asset managers, stemming from, as we've seen, some of the obligations that have been imposed on them by the prior rules, but as well, any voluntary efforts that they have undertaken. So in sum here, it maybe feels like a zombie apocalypse in the US court system. Again, very broad potential cast of characters of who can be a potential plaintiff. So we've seen actions by shareholders, investors, there's classic activists and nonprofits, there's consumers, either individually or as representative as a class, there's regulators, including all of the agencies that we've previously identified have not only issued rules, but in general, I think have signaled an increased appetite for enforcements, and as well, governments, community groups, and any classes of these individuals as well. So very interesting metric, and I suspect we'll see more of these surveys coming up, but there was a study undertaken last year of 430 GCs and in-house litigation leaders that looked at whether they're facing ESG litigation, whether they have concern about facing it. And just as of last year, in 2022, 2% of these surveyed had ESG litigation or were handling ESG litigation against their company. In 2023, this sort of incredible increase, 28% had faced ESG litigation, and another quarter of respondents, even if they didn't have it, expected it this year. So again, each of these could be their own probably hour-long presentation, but in terms of some best practices, one of the ways, including the first bullet, is webinars like this, staying informed about relevant laws and regulations, adopting robust ESG policies and practices, considering due diligence and assessment that are led by counsel to best protect under applicable privileges any information that's discovered, implementing risk management protocols and procedures, and basically communicating with customers, vendors, stakeholders, and again, sort of a trust but verify. So whatever statements are made, whatever data is gathered, that it meets reality with facts on the ground and what the company is actually doing. And with that, I'll turn it back to you, Bastian.
Thank you, Alex. So I think if I'm looking at the time, we are quite in time, and I think we have some time left for some questions. And I got already some here, and the first one, I think we can stay with you, Alex. That's a question for you. In the US, why is embracing ESG essential for all companies, public and private, even before regulations come out? First one.
Sure, a couple different reasons. First off, as we heard from my colleagues Sara and Anke, that to the extent companies, even if they're located in the US, are supplying to German entities or supplying or purchasing from EU entities, there's just an interrelated of global commerce component. But also I like to look at, for example, Larry Fink, CEO of BlackRock, has made this very clear on all fronts on ESG, which is it can simply be good for business to start to account for environmental, social, and governance factors, that it tends to be a approach that forces a candid assessment of the company's operations and impacts of the operations. And you have also seen, and I think we'll see more of this, but various studies that look at companies that adopt or don't adopt ESG and ESG related policies, and the possibility of, if there's not necessarily upside benefit, there's at least downside protection, that looking at these issues tends to identify longer term risks that may not crop up in a day-to-day sense, but may be relevant for the long-term sustainability of the business.
Perfect, thanks. I think we have a question for every one of you. So I'm coming to Sara. Your question is, what would be your recommendation? What steps should a US company take that has substantial business with German in-scope customers?
Sorry. Yeah, I think there are a few things that could be considered, because also not just because of the German legislation, but also of the coming European legislation. So it's in any case recommendable to update the existing compliance management system, and also maybe to carry out a risk analysis already, a voluntary risk analysis, to see if there are any risks in your supply chain, because you will be asked by German customers, if they are in scope companies, to give some assurances, or you may need to fill out questionnaires, self-assessment questionnaires and things like that. And also it is recommendable to update your own, if you have a supplier code of conduct, to update it, or to have something in place which also is aligned to the German or EU legislation. To also the topics should be touched in the supplier code of conduct. And also maybe it's another thing to agree on audit rights with your own suppliers, or to have contractual assurances from your own suppliers, and to, yeah, what else? Is there anything else, Anke? Did I miss anything? yeah, maybe also to prepare a self-declaration. This can also be something we've come across, that German large companies ask their suppliers, which are their non-German suppliers, to sign a self-declaration, and maybe it's better to have something in place on your own than having to sign something which has been drafted by your customer. Yeah, I hope this answers it.
Thank you. I hope so too. Then I have a final one. I think, surprise, surprise, it's the one for Anke I picked. Is a self-disclosure statement signed by a supplier sufficient to fulfill the due diligence obligation with regard to that supplier?
Well, I think this goes a little bit into the same direction as the question before that Sara answered, because Sara mentioned the self-disclosure statement as one possible building brick of the due diligence obligations. So yeah, you cannot say that by providing such or requesting such statements from your suppliers, due diligence obligations will automatically be fulfilled, but all the other obligations will also be need to be covered, in particular the risk analysis and preventive measures. So the self-declaration is indeed a very useful tool, I think, but it is just like one pillar of the entire picture.
Okay, thank you. Yes, I think the perfect end. I think we're running out of time a little bit. Thank you for being with us today. Thank you for
maybe
our
I can mention
today.
one more thing. Sorry
Okay.
to interrupt you.
Yes,
but if you have
no
any
problem.
questions, because I see that there's an entire list of questions and we couldn't answer all of this. We've already spent more time than expected, and so you can also individually write to us and we will answer your questions.
Yes, happy to do that.
Perfect. Then again, thank you for being with us today. As I said, you will receive the presentation as well as the recording afterwards in a follow-up email. And just one more thing for you all: when you leave the session, a short survey will pop up there. We would be very happy if you could give us some feedback on the webinar today. That would be great, and just to get better at any time. And yeah, thank you very much. Bye for now. Have a good day. Wherever you are, have a good evening. I have a good evening. Alex, you have a good day, hopefully. Bye-bye for now.
Goodbye.
Thank you, everyone.
Thank you. Bye.